David Williams,
Here.
Natalie Lawson,
Here.
Josh Broadbeck,
Present.
Aaron Saladay, and Sharif Thielen are absent, but you have a quorum.
Great. Today is Wednesday, July 16th of 2025. It's now 9 a.m. This is a permanent rulemaking hearing pursuant to the Administrative Procedure Act found at Section 24-4-103 of the Colorado Revised Statutes. To hear oral testimony and accept written submissions related to proposed amendments concerning the rules governing the practice of mortgage loan originators of the Board of Mortgage Loan Originators referenced in the Code of Colorado Regulations as 4 CCR 725-3. Section 12-10-72 of the Colorado Revised Statute authorized the Board of Mortgage Loan Originators to promulgate these amendments, these administrative rules. The permanent rulemaking hearing is being conducted in pursuant to the process as set forth in the Administrative Procedure Act. During this hearing, the board will hear testimony and accept written submission in regard to amending Rule 5.7 and 5.8 with respect to the tangible net benefit disclosure requirements. In addition to my fellow board members, here with me today is Director Marcia Walters, Deputy Director Jared Lyle, and Senior Advisor Melissa Phipps from the Division of Real Estate, Education, Communication Policy Manager David Donnelly, and Anthony Lawley from the Attorney General's Office. This public record will consist of all testimony and any written information submitted within the allowable time frame. Therefore, in addition to all public comments today, the board will review all written materials to make final decisions on the proposed amendments. The public record will close at the end of this hearing. Now let's have Director Waters explain the proposed amendments to the Rule 5.7.
The board members, the proposed revisions to this rule would basically change when the analysis of a tangible net benefit would need to occur. And the proposal is to strike that it's no longer required for a purchase transaction. It would just be for a refinance, a loan modification, or if you were acquiring an additional loan. That would be when this rule would come into play.
Thank you for the explanation, Director Waters. At this time, we will start the testimony phase of the rulemaking hearing. Each speaker will have 3 minutes to speak. Please speak clearly and slowly for the record. Please state your full name and identify the name of the organization that you are representing, if applicable. Finally, please limit your testimony to only the proposed rule amendments and do not duplicate testimony. Should the board have any or its representatives have any questions regarding your testimony, we will ask you when you finish your testimony. If you desire to provide testimony, please raise your virtual hand so the division staff will know who to call on.
Thank you, board members. As the chair indicated, there is a raise hand icon in the Zoom platform menu, and if you would like to speak, and board members, it looks like we do have a Jane Bale. Jane, I have asked you to unmute, so you should be able to unmute yourself now and address the board. Thank you.
Good morning, board members. Thank you so much for the opportunity to speak with you. Thank you too for your time, service, and dedication to our industry and to the Colorado consumer. I appreciate it. I've been in this industry for over 40 years. I participated in the amendments made to this actual disclosure, and I support this change. I actually would support deleting the document completely. The ATR, the refinance purpose, the QM rules that have been, put into place by the CFPB, protect the consumer from abuse. Oh, I'm sorry, I didn't tell you what I represent. I represent myself. I'm a licensed mortgage loan originator. I am also the past president of the Colorado Association of Mortgage Professionals and past government affairs committee chair. That's how I was involved with the document. The form I find in my end of the world, I am a broker. is not used properly. The spirit of the document is wonderful in that it promotes that the mortgage loan originator have an actual conversation to the benefit of doing this transaction. It promotes a conversation with the MLO and the client that there's an ability to repay the loan. I love the document. I love the spirit of it. I just find that it's redundant in our current landscape of underwriting. I do find that the lenders I work with, since I'm a broker, they issue the document. I really have no control over the document, and it's sent to the client to be signed. So the actual conversation can be deleted in the circumstance that I'm showing you. And you know, a lot of us are brokers, and a lot of us do not actually present our actual documents to the clients. It's all electronic nowadays. I have found some lenders signing as the MLO instead of the MLO signing. I've found the form is just totally misunderstood by most of the lenders I work with. I've tried to educate them, but you know, I'm just one little guy, and I always refer them to Dora, to you guys. And I try to talk to their legal team to get them to do it the right way, because, you know, I do believe in the spirit of the document. But so going forward, and I just wanted to share with you all of that information, that's what's going on in the broker world. It's not being used properly. The ATR is there. The underwriting guidelines for doing a loan nowadays with QM is just, we can't do loans the way they were abused before, which is wonderful for us and our consumers. So anyway, I do agree with the change, and would even, you know, agree further with deleting the document completely. Thank you for your time.
Thank you for your testimony. Any questions for the speaker?
Yeah, I have a question for the speaker. So, if I understood your testimony correctly, your assertion is that by retaining the document, it's redundant. So, can you tell me, give me an example of an actual transaction or scenario where this redundancy causes a problem? Is there a problem that we're trying to solve for, or is it just redundant and that's it?
Thank you for your question. I just believe it's redundant. I don't believe it's destructive or harmful. It's just another added document. A lot of the times you'll see the document issued at application, which is the appropriate time for it to be issued. But you'll also see it issued again at closing, even though there hasn't been a change. And most of that is because the lenders that are issuing the documents don't understand the rules that Colorado has put forth. They just have this document and say, oh, it has to be signed. But I don't see any harm in the redundancy, and especially for a refinance.
Okay.
Are there any other people there? David?
Board members, thank you. No other individuals have identified themselves at this time with the raised hand icon. So I will let you pass that back to you and for next steps. Thank you.
Thank you. That ends the testimony portion of the hearing. We will now consider the proposed amendments to Rule 5.7. Do I have a motion concerning the adoption of the proposed amendment to Rule 5.7?
Is the motion to open it for discussion, or do you want
To
the
adopt
motion
it.
to adopt it? Okay.
Board members, you definitely can make a motion and then have a discussion after you have a motion and a second.
So moved. Or I move to adopt the proposed rule changes.
Do I have a second?
question. I think Jane's comments and testimony are, I agree with them 100%. So is that something that we would be able to do, is to just get rid of the form completely or not?
So if the board wishes, you could vote to repeal both of these rules.
And repealing the rule would just say we're not changing it to now just be required for refinances. We would keep the same rule, go back to the drawing board and say we want to get rid of it, or we could say let's get rid of it today.
So if you want to get rid of it today, you can repeal them and they're gone.
Got it.
If you don't adopt the changes and you don't repeal them, then it will revert back to the existing language.
Okay.
And your statute says that you may adopt rules regarding this. You don't have to have rules, though.
Okay.
So if you're seeing that it's redundant and like there's just not value to this additional work, and I think what I had done kind of a quick internet search, and it looks like Colorado may be one of 8 states that does this type of disclosure. So if you decide that you don't want to move forward with having these rules on your books anymore, you can vote to repeal 5.7 and 5.8. I would repeal both if you're going to repeal them.
Yeah, I think you know, I'm a broker as well, but recently a few years ago I was a lender and it was no different. The form is not, you don't sit down and go over it with your clients. It's just sent over in initial loan disclosures. They e-sign it. Half of the time they don't know, you know, necessarily unless you tell them, you know, where to sign and what the form is for. And yeah, I'm in agreement with Jane. I would love to see the form go away.
So do you want to make a motion to that effect?
Sure. I would make a motion to repeal 5.7 and 5.8.
And so we haven't gone over 5.8 yet, so I would
Oh.
keep your motion strictly to 5.7 for now.
Okay, 5.7.
Do I have a second?
No
For
second.
the sake of opening it for discussion, I will make the second.
Okay, the motion carries and proposed amendment to Rule 5.7 are, I guess we'd say adopted at this point, right? What the proposed?
So you've got a motion and a second to repeal 5.7.
Okay,
Now I would open it up for discussion. And then you can take a vote after the
Okay.
discussion concludes.
So I just want to be, I'm no fan of redundancy. And so I'm happy to aid in getting rid of it. I just want to make sure that as the arbiters of fact, the staff agrees that this is redundant. Or is there another purpose that it's there that we would be eliminating another usefulness or another useful attribute of this by getting rid of it? Or do you agree that it's redundant?
I agree that it's redundant and I believe it's archaic. It was created in a time where these conversations weren't necessary, but as Jane said, we have ATR, QM, there are many instances. I mean, I guess one thing I wouldn't think of is maybe like non-QM loans, but I don't know that the form is required on all of those anyway. I guess it is on like bank statement refis. I don't know that those programs have the same rules. So I guess that brings up one really good point, like where's the safety in those loans? But I do have belief in where mortgage loans are today and the underwriting standards, that we're all having to CYA multiple times. And the form is there really just to CYA, in my opinion. That's
Okay.
not a professional term, but it's the best one I could come up with.
Can I ask staff to weigh in on this from a factual standpoint?
So I think one of the unique things about this form is you're holding a licensee accountable for a consumer actually completing the form. And the consumer is supposed to be identifying the benefits for that loan. I don't know, and I'll defer to Garrett's team on this one. I don't really recall seeing this being a big violation in the disciplinary cases that we've brought in front of the board.
Okay.
And I also don't recall that. Nicole, Paul, do you guys have any insight?
I don't recall ever saying that as a violation.
Yeah, it's certainly not something that I've seen over the last 3 to 5 years. Quite some time.
Okay.
So I think if you decide to get rid of these two rules, the statute still allows you to evaluate whether somebody operated in good faith and fair dealing. That won't take away your ability to address issues if you are able to assess the facts and determine that somebody did not operate in good faith and fair dealing.
So we're going back
Chair,
to,
that's all I had.
okay.
So you have a motion and a second to repeal 5.7. Mr. Chair, would you like to take a vote?
Yes, let's take a vote. All in favor, say aye. Aye.
Aye.
Any opposed? The motion carries. Now we'll consider the proposed amendment to the Rule 5.8.
So board members, the rule as filed, the proposed revision was to change the timing of when the disclosure was required to be completed. The existing rule required that it had to be disclosed within 3 business days after receipt of the loan application. The proposed modification was only to require that it be completed prior to or at the closing. And that's basically the change to this rule.
So in light of what we just did on 5.7, it would seem to be appropriate to move forward with this. Do I have a motion to remove this as well?
Do we
So
still need to do
moved.
the public comment portion for this rule?
Oh,
Thank you, Ajilali. Once again, if any individuals from the public would like to speak, please feel free to select the raise hand icon from the Zoom platform, and you will be identified. Board members, if we can just give that a few seconds here. Not seeing anyone as of now.
Okay, so we're ending that proposed portion on Rule 5.8. Do I have a motion?
motion to repeal 5.8.
Do I have a second?
I second.
All in favor, say aye.
Aye.
Aye. Okay. The motion carries and is adopted. This concludes the rulemaking hearing. Thank you.
So board members, that takes us to the regular public meeting, which I will do roll call again, just in case anybody dropped off, although you didn't. But to do a roll call, David Williams,
Here?
Natalie Lawson,
Here.
Josh Broadbeck,
Present.
Shirley Thielen, and Aaron Saladay are both absent, but you have a quorum.
Great. Can I have a motion to approve the board minutes from May 21st, 2025?
So moved.
I have a motion to approve the minutes. Do I have a second?
I'll second.
There's been a motion and a second to approve the minutes. Is there any discussion? will now take a vote. All in favor, say aye.
Aye.
Any opposed, say no. We have a number in favor. The motion passes. Next on the agenda are other matters. Does any of the board commission have any other matters to discuss?
Is there anything that you would like on your September agenda for discussion?
I don't have anything. Anybody
I
else?
don't have anything.
I'm good.
So I will flag for you, I do plan on putting a discussion item for your September meeting about shared appreciation loans. Because I would like the board's direction on how you would like to deal with that type of product. There's been, last year, Eric Turner and I had a couple meetings with a couple different people that do those types of loans, and they didn't feel that they needed to be licensed as an MLO to do shared appreciation lending. And it's been the division stance that you do need to have an MLO license, but I would just like to get some direction from you all about how to best address that issue.
Okay. Cool. All right. Next, we'll move on to complaint matters. The lead investigators will identify the complaint matter on your agenda, the case number, read a summary of the case, identify potential violations and recommendations, and a possible case resolution. They will also notify the board regarding who the investigator is there to answer any questions.
Before we go into complaint and investigations, can we check to see if there's any public comment about your meeting in general?
Okay.
Thank you, Director Waters and board members. Once again, if any individuals from the public would like to select the raise hand icon from the Zoom platform, we can unmute you and be identified. However, with that being said, board members, I'm not seeing any raised hand icons, so then we can proceed back on to the next order of business. Thank you very much.
Okay. Sorry, I jumped ahead there.
Good morning. The first is complaint matter A, complaint number 2024-2284. On December 10th, 2024, the respondent entered into a consent agreement with the State of Florida Office of Financial Regulation. The order called for a fine of $3,500. The fine was paid on December 4th of 2024, and this discipline was self-disclosed to the division by the respondent. Possible violations include 1210, 713, 1W, license discipline in another jurisdiction. However, we are recommending a letter of concern, being that no other states have disciplined, and to avoid continuing to tack on more fines when Colorado wouldn't have considered the failure to timely submit audited financial statements a violation in Colorado. And Investigator Martinez can answer any questions.
Are there any questions, board member? Okay. Do I have a motion to accept the staff's recommendation?
So moved.
I second.
All in favor, say aye.
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 Okay. The motion carries.
And the next is licensing matters. Matter A is an application. It's complaint number 2025-766 and also 2025-814. As a result of involvement with a mortgage loan originator testing and education scheme, the respondent executed a settlement agreement and consent order with the state of California on December 8th, 2021. The settlement ordered that the applicant complete a 90-day surrender of his California MLO license, complete 20 hours of pre-licensing education, 8 hours of continuing education, and pay a $1,000 fine. The fine was paid on January 31st of 2022, and the applicant's California mortgage loan originator license is currently active. And we do not have a recommendation per usual, and Investigator Martinez can answer any questions.
Are there any questions from the board members?
Do we know if if anything like this has come before us in the past so that we would have the same response? I thought we saw another case with the same continuing education.
There have been several, right? Yeah, there have been several of these brought to the board, the same exact
Scenario. Yeah, and I believe we approved the license, if I remember correctly.
I think it's dependent on the circumstances because while you have seen a lot of these, there's different nuances. Some of the language in the different orders is different, depending on which licensee you're dealing with. Some of them, when they realized what was going on, took education to try to rectify the situation. So I think you've made a decision based on those different circumstances. I don't think everything has been like all of the circumstances have been identical for each applicant.
Okay.
Do I have an emotion? Go ahead.
This person did it more than once, if I'm reading correctly, right? He said he did it the 1 year and then he did it again the second year. Did anybody read that as well?
Reading that.
Yeah, he cited just 2021 in this statement.
Let's see. He said, I did figure out after I paid the class and my certificate showed up in my inbox without having to do anything. That's when oh crap set in. But yet a year later, when it was CE time, I continued down the dark path. It was easy. I knew the content anyway was my justification.
I think he might be on a different case.
Oh, okay. It's license matter A. Yeah, that's what folder I'm in.
You're in 766?
Yeah. It's under the exhibits 02 complaint, his what he filed.
Paul, you're on mute.
Sorry about that. So in the statement, he is citing in Exhibit 6, he's stating 2021 as the actual time of violation there.
Any other comments, Natalie?
No, I was just looking for where he said it was only 2021.
So it's in Exhibit 6, and it's the part of the recent, so the opening line.
Got it.
And then the actual consent order, so that only covers the 2021 conduct, it looks like.
Yeah, it says he was investigated in 2021.
Yeah.
But it sounds to me like in Exhibit 2, he's saying he did it for 2 years.
Yeah, so they're saying that they got in the consent order, it's saying that they got notification in late 2020 of suspicious activity.
Okay.
So I wonder if that's something that carried in over to 2021 when this because the consent order was executed at the end of 2021. Unfortunately, it doesn't outline the specific dates of the courses that are in question here.
Got it. That would be, just be my concern is if you got away with it the first year and then you did it a second year, it just shows a little less, like he said, oh crap, it set in what I was really doing, but then you did it a second year would be my concern. But that would be it. I don't know if anybody else has anything else to share.
It concerns me that this respondent put no effort into finding anyone to speak on his behalf. That concerns me. And he even explains in his statement he didn't want to do it because he's embarrassed of his conduct. Well, yeah. That's why we need to hear from people who know you and who can speak to your character and your qualifications and knowledge, skills, experience, abilities as a mortgage loan originator. Unless I'm mistaken, his suggestion in his statement that we go find people to speak on his behalf, I don't even know that the Division of Real Estate would be allowed to do that. But even so, for him not to invest any effort, that's really concerning to me.
Okay.
I think that brings up a good point. My only thought with the character letters is I think anybody can get, I mean, especially in the mortgage industry, there's so many people who can write a character letter. So I kind of take those as
I totally get your point,
Yeah.
Natalie, that people can orchestrate those and they can manipulate those. I get it. That goes on. That being said, I do believe that we can tell the difference, right? When someone writes a character letter and they really take time to describe, here's how I know this person, I take those seriously, but I can tell the difference between a letter that's like that and something that you can tell the respondent wrote for them, or manipulated or orchestrated, because your point's valid. That notwithstanding, the fact that he put no effort into it and then flat out stated, I'm not going to put effort into it because I'm embarrassed of my conduct. To me, that's suggestive of that's the kind of thing that you do when you want to avoid accountability.
Right. I agree.
That to me is concerning.
Okay. Do I have a motion in case number 2025-766?
I'm torn, so I'm kind of split down the middle, David.
Yeah, me too. I was hoping one of you would weigh in and sway me.
I mean, it was a pretty rampant, organized deal when this all came down. This education company that did this, it was pretty crazy when it happened at the time. And I don't recall what happened to the guy that had it, but I know there was a lot of people caught in it. For the path of least resistance to not have to go through the education process. I'm not saying that's right, but
Do we know what other licenses he holds? Does he just hold California?
At the time that we had done the report, looks like it was California, Idaho, Tennessee, Texas, and Washington.
And that was, when I checked today, it was the same 5 states.
Got it.
so they would have gotten the same notices that we got about past actions, and they've left the license stay in play. Okay.
Yeah, it was disclosed on the NMLS registry, so every state that he's licensed in would have been able to see that disclosure.
And then the consumer, if they were looking it up as MLS numbers, would they see that as well?
I don't know if they made this public. I have a regulator view, so
Okay.
I'm not able to see it the same way that the public can see it. Let me check for you though. We can verify right now. Okay, yeah, it looks like it's public.
Is it?
Yes.
Okay.
Yeah.
So for someone who knows to look, they could find out about this, but you have to know to look and you have to know where to look.
Well, it comes up as soon as you search his NMLS number. So essentially it's a click away from once his name comes up. So I don't think
Okay.
it's would be difficult for a consumer to identify.
Okay.
Assuming that they know to use the NMLS registry, which
Right.
Okay.
Oh, man.
Am I able to make a motion as the chair or no?
I
Yes,
suppose
you
you
may.
can entertain a motion.
There's only 3 of you, so you're more than welcome to make a motion.
Okay. I make a motion to approve case number 2025-766. Do I have a second?
I'll second.
All in favor, say aye.
Well, can we discuss?
Discuss? Okay.
What would be our options for a restriction to go along with the approval? What are the options there?
So MLOs are a little different than like real estate brokers. They're not subject to supervision like real estate brokers are. So you could restrict, you could do a practice restriction or basically a probationary license that says for X amount of time you can't have any violations of the license law. That's an option.
And would a standard acceptable period of time be like 2 years, 1 year? What's typical there?
I think for another program, it's pretty typical that we see 2 years. This board doesn't do too many restricted licenses, so it's definitely up to the board, but I think 2 years sounds reasonable.
Okay. So if you're open to it, Dave, I'd like to make a friendly amendment, move for a friendly amendment to accept the application, but with a 2-year restriction for no further violations.
Do I have a second?
I'll second. That's fair.
All in favor, say aye.
I
Aye. Okay. Motion carries. Do we have a next?
The next is license matter B, complaint number 2025-832. This is an application. As a result of involvement with a mortgage loan originator testing and education scheme, the applicant executed a settlement agreement and consent order with the states of California, Texas, Oregon, Idaho, and Washington on December 22nd of 2021. The order called for a $5,000 fine and a 3-month license surrender in 5 states. All fines were paid on March 7th of 2022, and all state licenses are currently active. We do not have a recommendation, and Investigator Martinez can answer any questions.
My thought on this one was he wasn't as apologetic. He was just very much in his letter, in my opinion, very victim mentality. So, I mean, that would be the only thing I would have to add. I would probably say that I would lean towards doing the exact same motion in this case.
I'm with you. Go ahead and make the motion and I'll support it.
Okay.
I motion to, I don't remember all the words, but to have the restricted license with a restriction of 2 years for license matter B,
And to approve.
Second.
and to approve the license
Okay.
with a restriction, yes.
Okay. Do I have a second?
Second.
All in favor, say aye.
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 Okay, the motion carries.
The next is license matter C. This is an application, complaint number 2025-1051. The applicant's Montana MLO license was suspended on October 17th of 2022 due to his failure to provide information and/or documents to the Montana Department of Administration, Banking and Financial Institutions Division, as per the agreement signed by the applicant at the time of his licensure. At this time, the applicant has no active MLO licenses in any other state. And we do not have a recommendation, but I can try to answer any questions.
Any questions there?
No questions, but my thought process on this one was he was not responsive, sorry, when he was reached out to on many cases, or in many different times via mail, phone. His phone number that was listed in NMLS was to some other man that said he moved out. So that was all kind of funky for me. But it was just, I think, and correct me if I'm wrong, I think the reason why this one is coming before us is just because of past credit issues, right?
That's correct.
Okay. So he's unresponsive with paying debts, and then also when reached out to from authorities, I guess. Not that that's a reason to not give somebody a license, but it is a red flag.
Well, and that the previous discipline was not disclosed on the application. As a board, we have previously, we don't look kindly upon that. Just be honest. That's all we ask.
Mm-hmm.
Turn in a true application.
I guess I missed that part. I didn't have that in my notes. But yeah, that says a lot to his character. I mean, I think we can all fall on hard times, right? All of us are a diagnosis away from having our worlds crumble, but not disclosing it would be kind of an issue.
And what you pointed out, Natalie, is just a continuation of the same pattern again.
Right. Exactly.
So do I have a motion in case number 2025-1051?
Sorry to interrupt, board members. It looks like Deputy Director Lyle wants to address you all.
Oh,
Yeah, board members, I just had a question. You mentioned that it wasn't disclosed in the application.
Yeah, I'm looking at the report. We're on 1051. And it says, was the discipline disclosed on the application? And that's checked no.
Right, with the note that although not disclosed on the application, as there is no section for disclosure, it was identified in the NMLS. So the MLO application gives you an opportunity to disclose past criminal action, but not disciplinary action in other jurisdictions.
Okay, my mistake.
So is there a motion with case number 2025-01051?
I don't know that my oversight eliminates my concern about Natalie's point, though. Mr. Chair, weigh in. What are your thoughts?
I read through his situation that he went through, in terms of all the personal stuff he was going through at the time. And, I've been involved in some personal, family people with those kind of situations. I guess I'm a little bit more sympathetic in that regards.
He also had a recommendation letter, right?
Yep.
And he's righting his wrong. He's paying everything. So I would motion to approve the license.
Do I have a second?
Second.
All in favor, say aye.
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 Motion passes. I think that concludes our licensing matters at this point. Are there any ESP matters to look at?
Not today, board members.
Okay. Any AG matters to look at?
No, sir.
Okay. I have a motion. Do I have a motion to adjourn the meeting?
So moved.
All in favor, say aye.
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 So moved. Meeting is adjourned.
Thank you, board members, and thank you, acting chair, for running the meeting.
Yes, great job, David.
Appreciate the patient first time through.
Thank you.
Everybody have a good
Everybody,
summer.
bye.